Hello friends, in the series of the income tax cases with the great initiative of Company Law Institute of India Private Limited, today we will discuss a very important case on the deduction of section 80P subsection 2 clause D. The name of the case is Maker Tower A and B Cooperative Housing Society Limited versus Assistant Commissioner of Income Tax. This case has been reported in 99 ITR, short notes page number 73, and the matter has been reported and decided on 18th October 2022. The facts of the case are like this. In this case, the assessee is a cooperative society. The main source of income of the cooperative society is contribution from the members, and whatever the surplus funds was with the cooperative society, that surplus funds was invested by the cooperative society into the investments made in the cooperative banks, and assessee was receiving the interest from that. When the assessment was going on, the assessing officer said that the assessee cannot be allowed the deduction under section 80P because the conditions for allowing deduction under section 80P is that, first of all, the interest and dividend should be earned from the investments, and that investment should be made into the cooperative societies. But in this particular case, the assessee has made the investments in cooperative banks. So the moot question was that whether cooperative banks are cooperative societies or not. When this matter came to the CIT appeal also upheld the order of the learned assessing officer by saying that the assessee was not in a position to demonstrate that the cooperative banks were cooperative societies. He was not able to demonstrate either at the time of the assessment proceedings or at the time of the appellate proceedings. The assessee has no option other than going to the ITAT. The ITAT in its order analyzed the whole matter. The definition of the cooperative societies is given in section 2 subsection 19 of the Income Tax Act. The ITAT observed that the cooperative society made investments into the cooperative banks, and the names of all those cooperative banks were in the list of the banks which were registered under the multi-cooperative societies. So the moot question was that whether inclusion of the name of those cooperative banks in the list of the banks which were registered under the multi-cooperative societies will convert them as cooperative societies. So the ITAT held that the coming of the name of the cooperative banks in the list which were registered with the multi-state cooperative societies is sufficient to allow the deduction to the assessee under section 80P subsection 2 clause D. It means that the definition of the cooperative society has been a little bit enlarged by the Honorable ITAT. So in this particular case, the Mumbai ITAT allowed the deduction under section 80P subsection 2 clause D to the assessee. So whatever the findings were given by the assessing officer and the CIT appeal were reversed by the ITAT, because at the time of the ITAT proceedings, the ITAT was convinced that whatever the investments have been made by the assessee in the cooperative banks, the names of all those banks were coming in the list of the banks which were registered under the multi-cooperative societies. So that inclusion of the name was sufficient, or in other words, we can say that that was sufficient to make them as cooperative societies. So in this particular case, the assessee got the relief from the ITAT, and the deduction under section 80P subsection 2 clause D was allowed. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Maker Tower A and B Cooperative Housing Society Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 99 ITAT Tribunal, short notes page number 73. Thank you, friends.